Welcome to Case by Case. This is a podcast brought to you by Luke Zadkovich. Today, just Luke Zadkovich. Callum Chain unfortunately couldn't be with us, but we have a wonderful stand-in in Romina Reyftmann, one of our associates at the law firm ZFZ. Welcome, Romina.
Hello, Luke. Hello from Australia.
Yeah, we're doing this one kind of cross-world, I suppose you'd say. So Romina's our pro bono associate and heads up our pro bono team, and so has all sorts of experience in that area. And I'm sure we will get you on to talk about a pro bono case one of these days. But today we're going into the world of Katy Perry.
So it's just been all over the news recently. So when you suggested that we should talk about it, I noticed that no one put their hand up on Teams, and now I realise because it's 190 pages.
Right, yeah. And you're not going to call me out, are you, on whether I've read every single line of the 100-page decision?
I'm sure with your experience you can pick out the relevant parts pretty quickly.
No, I gave it a good crack. And no, I'm looking forward to getting into this. So yeah, we're talking about the trademark case in the Federal Court of Australia. To just get the parties' names in from the outset, this is the case of Taylor versus Killer Queen LLC and others. The citation is 2023 FCA 364/2023. It's a decision of Markovich J, and the decision was handed down very recently on the 21st of April 2023. And yes, I put the feelers out there into the team and said, who might want to talk about this case? We have Katy Perry versus Katy Perry, spelt differently. And it made global news, this case. And Romina wanted to jump on and sing Katy Perry songs. So that's what we're going to do today, isn't it, Romina?
Well, no, and also I wanted to help the team because I'm the pro bono person in the team, and I realised how big it was. So, get other people to focus on the billable work. So I think I'll take one for the team for this one.
Very good, very good. No, look, it's an interesting case from a legal perspective. With putting all the sensational headlines to one side, and no, we're not going to put you through us singing Katy Perry songs, as tempting as that might be. And we're going to get into some law on this case and kind of start from the start, go through some of the facts. I might lean on you, Romina, for some of the factual background, and then we can actually get into the law. What was this case all about from a legal perspective? So yeah, would you like to kick us off with a bit of a summary on what are we talking about? What's the background to this case?
So this is a case between the applicant, the dark horse of the story, the first Katy Perry lyrics on there. She's an Australian designer by the name of Katy Perry with an IE, and the respondent, Killer Queen, an incorporated company based in California, which was established in August 2009. And its sole shareholder and officer is Katie Hudson, otherwise known as the very famous singer Katy Perry, spelled with a T-Y. The one who got away with using an existing Australian trademark until last Friday night, the 21st of April 2023 to be exact, which happens to fall on a Friday night. The Federal Court of Australia gave injunctive relief to one of the parties who was able to roar and live out her teenage dream.
I see what you did there. Huh? We might have to weave in a few of these kind of references to names throughout, and song names and lyrics throughout the pod. But yeah, so two Katy Perrys, one actually goes, but the irony is that it's a dispute about the use of the mark Katy Perry, and yet neither of the individuals actually are called Katy Perry. We have Miss Taylor, who is the claimant, the Aussie, who's in the clothes business, and Miss Hudson, who is the world-famous singer, Katy with a Y, Perry.
So yeah, the applicant is called Katy Jane Taylor. She's the fashion designer and is the registered owner of an Australian trademark for the word Katy Perry, which in this case is called the applicant's mark, and it's registered in Class 25 for clothes under registered goods, with a priority date of the 29th September 2008. Miss Taylor has designed and sold clothes under the brand name Katy Perry since about 2007. And then we have the second respondent, which is Catherine Hudson, the music artist and performer. In 2002, she adopted the name Katy Perry for her music career, merchandise and licensing activities. In this case, she's referred to as Miss Hudson. And the first, third and fourth respondents are companies associated with Miss Hudson and are called Killer Queen, Katy Perry and Perfect Ventures. So they all have cat associations on them. So the case is Taylor versus and Killer Queen. So Miss Taylor alleges that the respondents have imported for sale, distributed, advertised and promoted, sold and manufactured in Australia or to people in Australia the registered goods bearing the word mark Katy Perry and the other marks set out in the amendment statement known as Katy Perry mark. And in the alternative, the respondents have participated in a common design and infringed the applicant's mark pursuant to Section 120 of the Trademarks Act, or are liable as joint tortfeasors. So the respondents have filed a cross-claim seeking cancellation of the applicant's mark pursuant to Section 88(1)(a) of the Trademark Act, and relying on Section 60, with trademark similar to trademark that has acquired a reputation in Australia, and Section 42, trademark that's scandalous or its use contrary to law, and Section 43, the trademark likely to deceive or cause confusion. So on the 7th of April 2020, Judge Markovich made an order pursuant to Rule 30.01 of the Federal Court rules that all issues of liability, damages for alleged trademark infringement, and claims for declaratory injunctive relief be heard and determined separately from this case. So this case just deals with the issues of the trademarks. And then now that a judgment has been given later on, that the relief would be decided upon.
I think, and it's important to identify this or emphasize this at the outset. We have a number of respondents. So on the singer side, on the respondent side, Katy with a Y, Ms. Hudson. On her side, we have companies of hers where she's a CEO and director. We have her herself, but there are a number of parties involved. And what's important about that is that there are claims for joint liability on the basis of joint tortfeasor liability in the infringement claim that Miss Taylor's brought against Miss Hudson and her companies. And a little bit of a spoiler alert, but Miss Taylor does not succeed against all of the respondents and only actually succeeds against the one of the corporate entities, which we'll get into and explain further on. But it's quite important, I think, to identify that at the outset, that the different respondents are not all going to be liable or not liable as a whole, and the court goes through each of them to see whether the individual entity or individual is liable or not. And so the kind of basic claim here that Miss Taylor is bringing is an infringement claim, and that's what the court goes through a lot of detail exploring. As you say, there's the cross claim, which is ultimately tossed, but there's a cross claim to touch on as well. But the primary issue in this judgment, and what the court spends a lot of time, as you say, 150 odd pages just on this part of the claim dealing with, is the infringement claim. And so the judgment is set out in a way where the judge methodically goes through the history. And as we know in trademark cases, it's really important to establish who had it going first, who had established the mark, what was the nature of the business. Then with the secondary business, the second one coming in after the first one, how did that then establish what was its timeline? What mark was it using? Was it similar or the same? And so actually it's quite an interesting read around, how these businesses were developed at around the same time. Miss Taylor's first, but in Australia, how they developed and ran in parallel. And I think it's a really interesting read, actually.
And I think for the players at home, especially for students in the law, I always get taught during my training, know your case. You know your chronology, know your case. So I think for this particular case, your chronology is really going to be quite important. So, yeah. So we have, do you want me to keep going with the facts or?
Yeah. Let's lay a little bit more out, a bit more flesh to the bone on the facts. Maybe starting with Miss Taylor's business. What was her business? What was she doing in Australia?
We only have two witnesses. So Miss Taylor, the Australian designer, and Mr. Jensen, which is actually the talent manager of Miss Hudson. So Miss Taylor's background and career, she was born Katy Jane Perry, but was known socially as Katy Perry since 2008. In March 2015, she became Katy Jane Taylor through her marriage. She completed her studies in fashion in 2003 and has worked in retail and fashion in London and various places in New South Wales, Australia, including Paddington Markets and Mosman. In 2007, Miss Taylor left her role at David Jones, which in Australia is a big shopping centre, quite high-end in some respects.
Yeah, big department store, right?
Yeah, so just, for the overseas listeners out there might not know what David Jones is.
Yeah, it's a John Lewis equivalent for the UK listeners or a Macy's equivalent for our New York listeners.
Yeah, so I knew that you'd know what the equivalent would be for David Jones. So Miss Taylor was determined to have high quality clothes that catered for a niche market, solely made in Australia. She wanted to decrease her carbon footprint by having garments made in the country that she could easily oversee and control. She understood that her entry price point for consumers will be a bit higher, and therefore her target audience were women in the 30 to 50-year-old age bracket with a higher disposable income. She first registered Australian business number on December 2006 and registered an email address with Katy.Perry handle in August 2007, registered a trademark on September 2007 under Class 42 clothing and fashion design first. And then she has done very small fashion parades, set up Facebook page in November 2007 and starting making small quantities of her clothes. But later, this is the interesting bit, Miss Taylor found out that she actually had not yet paid for her first trademark.
Right.
And that prompted her to apply for a Class 25 trade word mark that would give her more protection because she went to a seminar that said that if she trademarked that, she'd have more protection. So if she wanted to change her logo later on, she'd be able to. But as her business was only starting, she couldn't afford to pay for the two trademarks. So she let the first one lapse and decided to register Class 25 for clothes, which is now the applicant's marks, and gives us the priority date of 29 September 2008.
Yeah, why don't we look at Katy Perry, the Miss Hudson's,
the singer. Miss Hudson's, yeah. Miss Hudson.
Miss Hudson's career and in summary form, but how that kind of it was interwoven with all of this.
So the respondent, Miss Hudson, on the other hand, was becoming more popular and well known around April 2007 with the release of a single, "You're So Gay." It seems so completely politically incorrect to say those things now. And this was advertised to as called MySpace. I'm showing my age because I don't think the younger students these days would know MySpace. I'm not even sure it exists.
I had the same thought. You know what? This complete sidebar. But I had the thought, I wonder whether you could bring back MySpace. Like, I wonder whether there's a market for a revamped MySpace.
Well, it's just called YouTube now. or TikTok.
Okay.
So I
right.
don't think they're going to, it's like dead and buried. I'm not even sure. I actually should Google if there's still existence. So back in the day,
Anyway.
artists would put, music on their MySpace. So Miss Hudson's first single went viral in November 2007. Her growing popularity to the point that even Madonna mentioned her in a new and up-and-coming singer on the radio. Record sales were through the roof. She was featured on various newspapers around June 2008, and her other hits such as I Kissed a Girl, Hot and Cold, Waking Up in Vegas went viral as well. She went on various promotional tours, was nominated for Grammys in 2012, performed at the Super Bowl, performed for Barack Obama, Joe Biden, so the lot. So basically, all the way up to the present point where she had a pregnancy reveal and released a song, Never Worn White. So she's quite well known.
I think it's safe to say that I don't think anyone listening does not know who Katy Perry is.
I'm sure there are people older.
Sure. Well, I don't know. She, as you say, she's climbed the pinnacle, the Super Bowl, right? Does it get any bigger than the Super Bowl?
2009, her talent manager, Mr. Jensen, became aware of Miss Taylor's application for clothes in Australia. And he was concerned that she was attempting to obtain a financial advantage because Miss Hudson was scheduled to tour in August 2009.
This is where the two businesses start to converge, right? We've got Miss Taylor, who has set up a design clothing business in Australia, operational, doing well. I don't know how well it was doing, but it was building. No, I don't think it was making a lot of money, but in any event, it was an existing business. Katy Perry, Katy with a Y, Miss Hudson, is coming to Australia on a promotional tour and has a bunch of merch to sell, right? Including clothes, including headgear, including footwear, including all sorts of things. And I set it out like that because that's actually a key part of the decision as to what products may have infringed the mark that Miss Taylor had. So anyway, Miss Hudson, the singer, is coming out to Australia to start selling, to perform, but in addition to sell her various products, some of which are clothing. And so we now have this clash. The mark that Miss Taylor has for clothes, the Class 25 registered mark, and these items that are then being sold by Miss Hudson on her world tour in Australia.
So in May 2009, Miss Taylor received a cease and desist letter from an Australian trademark attorney instructed by Miss Hudson's US-based lawyers to the effect that she should withdraw her Australian trademark immediately and that she's prohibited from using a mark that is substantially identical or deceptively similar in the future. Miss Taylor felt very intimidated and distressed by the order, and she felt she was being bullied into signing off everything that she had worked for. She felt that she hadn't done anything wrong, but she wouldn't give up without a fight. She felt that her label, being made and produced solely in Australia, was a big part of the brand's identity and was her biggest marketing point. So in June 2009, Miss Taylor received further letters from Miss Hudson's lawyers as a final opportunity to correct your wrongful behaviour and to give up the trademark you have applied for. So on June 2009, Miss Taylor knew that she could not afford a costly showdown, which led her to post an appeal to Miss Hudson on YouTube to say that she was absolutely no threat to Miss Hudson and that she hopes to settle the matter beforehand and come to an amicable agreement. On July 2009, Miss Taylor received a draft deed of agreement from Miss Hudson's Australian lawyers, and neither party could come to a mutual agreement. And Miss Taylor was really lost as to how to defend her trademark, but by serendipity found a family connection that introduced her to the concept of litigation funders, which happened to know the litigation funders is one of the board members of the charity that I work for. So it's quite funny that he's on this case, or random. So it is, especially the Australian jurisdiction. So Miss Taylor figured out that if she used a litigation funder, she won't have to pay any upfront cost, but the funder would take a cut out of any successful damages award settled. And then her proceedings started on the 24th of October 2019, pleading that her case, that the respondents infringed the applicant's mark as a term registered good means clothes, and citing also the priority date. And that's when later on we go into the discussion of what is the definition of clothes, etc. But I'd like to, as a commentary from a feminist point of view, Luke, it's just funny because of reading, I mean, these two probably ordinarily they'd get along, maybe, if they won't have to go through the trademark thing, because they're both entrepreneurs, they're both women, both named Katy Perry, and they're both hardworking, and they're both, want to protect their brand. So it's just unfortunate that this has had to happen, but they have a lot in common.
It's interesting, isn't it? Because, you do wonder, whether there at some point could have been a collaboration, or some type of way of, the big name Katy Perry singer involving Ms. Taylor in some way, in some shape or form, and making a play of it, right? Making light of it to Katy Perry. It's like, maybe that sounds naive and what have you, but I don't know. I had the thought that it sounded like at one point Miss Taylor reached out and was like saying, I'm not a threat. I kind of want to find a way to deal with this. And, Miss Perry, through heavy lawyers, came and said, forget it. We're gonna crack on. You're in breach of our mark and what have you. And anyway, we've got to where we are.
That there was probably a way for them to broaden their market, both of them, because they're a substantially different market. I mean, Katy Perry deals with the singer with younger audiences, more bright and sparkly, and then you've got the conservative looking, very, niche market Australian designer Katy Perry. So I think it's a missed opportunity, I think.
Yeah, much better than ending up in this kind of situation, I suspect. But there we are. And yeah, we've seen other disputes in the music space recently over use of songs and what have you. I'm thinking of Ed Sheeran recently in court. Completely different case, of course, but there can be an aggressive kind of approach to some of these decisions, some of these cases where the artist really wants to try and protect their legal capital, and I imagine there's some significant sums involved here. I don't think we really know from the judgment.
They struck that off the record. I think that's all commercial and confidential right in the end of the case. So there are 4 main issues that I looked at, Luke. I don't know if you wanted to.
Yeah, let's hear them.
So because there are a few issues, but for the interest of the podcast in terms of time. So issue 1 is whether any use of infringing mark in relation to goods of the same description as clothes is unlikely to deceive or cause confusion, and whether the respondents have ground for cross-claim, and whether defence is available to the respondent by using an own name defence, and what relief can be sought. Those are the 4 main issues that I thought maybe we could focus on. Unless you want to focus on other things too.
No, I think that's right. And look, I think the place to start is the infringement claim, as you say, and the claim under Section 121 of the Trademarks Act. And just to read this out, I think is probably the place to start, and then we can unpack it a little bit. There's 2 elements to it under Sub 1 and Sub 2. Under Sub 1, a person infringes a registered trademark if he or she uses a trademark, a sign that is substantially identical with or deceptively similar to the trademark in relation to the goods in respect of which the trademark is registered. So that's Section 121 of the TM Act. And then the second potential infringement here is under subsection 2. A person also infringes a registered trademark if he or she uses a trademark, a sign that is substantially identical with or deceptively similar to the trademark in relation to the goods of the same description as that of goods in respect of which the trademark is registered. Now, there's no dispute that the mark, and it's admitted by the respondents, that the mark used by them, so by Miss Hudson, the singer, is deceptively similar to Miss Taylor's mark. That's not in dispute. What is in dispute is use under subsection 1, use as a trademark sign. And then under subsection 2, the issue there is whether the goods are of the same description as the goods to which the trademark is registered. So we have kind of two issues to unpack, and the court then starts with looking at the primary claim under section 121 and explores what does use as a trademark mean. What does that mean? To unpack that, looks at some previous decisions. So it looks at the Playgro and Playgo decision, and unpacks some of the principles on use and use as a trademark from that decision. That was another Federal Court of Australia decision from 2016, so not that long ago. It was about toys from China. And in that decision, there was also reference to the old case in Estex Clothing and Ellis and Goldstein from 1967, and the E&J Gallo Winery and Lion Nathan decision of 2010. And one of the key points of that decision was that when looking at the word use, that the definition of trademark, and that is particularly the mark, is that it's used or proposed to be used in relation to goods for the purpose of indicating a connection in the course of trade between the goods and a person who has the right to use the mark. So it's the mark. The use of the mark goes to this connection point, the connection between the goods and the connection between the person who has the right to use those goods. And then when you kind of unpack use of that trademark, use of the trademark is use of that mark as a badge of origin. Again, in the sense that it indicates a connection in the course of trade between the goods and the person who applies the mark to the goods. So it's this concept of, connection and badge of origin. And that's what use is intended to mean. And what's important about that is that it's objectively assessed. So it doesn't matter what the subjective trading intentions of the user are. It's an objective test. And then there are different ways that a mark may be used. So for one of the examples that was used here was use of a trademark on a website, and whether the websites that were advertising the clothing of Miss Hudson, the singer, her clothing in Australia, whether that was use of a trademark in Australia. And one of the interesting points about that is that the infringing conduct needs to happen in Australia. And so you have some cases talking about, well, when does uploading a trademark on the internet become use of that mark in Australia? And just by putting it on a website in and of itself doesn't necessarily mean that it's been used in Australia. There needs to be some additional targeting towards the jurisdiction. There needs to be some display that suggests that the mark is being advertised through the website in the country or sold in the country. And there are a number of cases. I'm distilling it right down here.
No, it's good, because this is where your experience comes in.
So yeah, that was one of the key issues well, one of the issues, I don't know if it was a key issue, but as to whether there was use of the trademark on a website in Australia. And there was some other discussion around use as well. The court then moved on to look at the issue of joint tortfeasors. And I touched on this at the outset. It's an important element of this decision in that the claim was brought against the individual Miss Hudson and a number of her companies. And one of the arguments here is that Miss Hudson, the individual, should be jointly liable along with her companies for infringing Miss Taylor's mark. And there's some good law on this around when you can make an individual liable for that type of infringement claim, and when you can't. And there's a couple of dimensions to it. If you could say that there was a relationship between the joint tortfeasors, such as an agent commits a tort on behalf of the principal or a master and servant type breach, that persons who are breaching a joint duty of such may also be joint tortfeasors. And so there's kind of a category of joint tortfeasor liability, which is premised on the relationship between the two joint parties and the nature of that duty. The other type of joint tortfeasor liability in these types of cases is when two or more persons act in concert in committing the tort. And so that's when two persons agree on a common action in the course of and to further which one of them commits a tort. And so it's this concept of kind of agreeing on a common action and then going ahead and performing it. And so in those types of cases, this acting in, almost like a complicit type claim, when you're acting together with someone else, and in those types of joint tortfeasor liability cases, it's necessary to establish that there has been this common design to participate in or induce, procure the other person to act in an act of interference, then an act of infringement as well. And so there's the court then explored this idea of common design, and we'll get into some detail on that. But in short, and to kind of jump to the conclusion on this, there was an agreement in place between, let me just pull this up, Katy Perry with a Y, her company.
Bravaduro or?
Yeah, the Bravado. Was it Bravado?
Bravaduro, B.
So one of the key issues here is whether Ms. Hudson herself individually should be liable in addition to her companies, Killer Queen and Kitty. So Kitty, like a cat, Katy Perry, which funny play on words. And the argument here was that from the respondents was that none of them should be liable on a joint tortfeasor basis, and that they did not act in common action or design with each other, and whether they acted in common action with another company, Bravado. Now, Bravado was the licensee. So Bravado had the rights under agreement to sell the clothing, sell the apparel, sell the footwear and these other items of Miss Hudson at her concerts in Australia. And the allegations were such that each of Miss Hudson, Killer Queen, and Katy Perry, her companies, had acted in concert, in common action with Bravado. It was almost clear. Bravado was not a respondent, but it was unarguable that Bravado had been using the mark and in selling those clothes into Australia. And I can only assume that, I don't know this, so by all means, anyone involved in it, feel free to correct us. But I assume that going after Killer Queen and Miss Hudson and Katy Perry directly were deeper pockets, and were perhaps parties that are able to pay this type of judgment more easily. There may also be some settlement value in going after the big name respondents as well. And when I say that, why not just go after Bravado? So in any event, we're looking at the liability of Miss Hudson's companies. And so what was important was what was the relationship between Killer Queen, Miss Hudson, Katy Perry, and Bravado? Whether there was either a relationship that created joint tortfeasor liability, or whether through the way that they acted, there was this common design. There was this kind of complicity, if you like, to use a different word, in a prerogative sense, that they were acting together. And so the court looked at the 2014 Bravado Agreement, which was an agreement between Bravado, Katy Perry as grantor, and Miss Hudson as the artist. And under that agreement, Katy Perry had certain tour obligations where Katy Perry had to use its best efforts to carry the Bravado's designated vendor and licensed products, and to work with Bravado to sell these products in Australia. And there were a bunch of obligations related to that. And what the court ultimately found was that by virtue of this agreement, it wasn't such that all the rights were handed over to Bravado, and Bravado had the license and they could just go ahead and sell. The agreement set up an arrangement whereby Katy Perry, so one of the companies had certain obligations to help sell those products, to help work with the licensee to sell those products in Australia. And that was enough to establish liability against Katy Perry. However, the court said that it was not enough to establish joint tortfeasor liability against Miss Hudson herself or against her other company. And the court found that Miss Hudson was the CEO and the director of Katy Perry, and so her involvement in approving certain things and taking certain steps was clothed, if you like, pardon the pun, within the corporate form of Katy Perry. The role that she was fulfilling was not in her personal capacity, but she was fulfilling a role as the CEO and director of Katy Perry. So
yeah, on paragraph 404, it said there was nothing unusual about Miss Hudson being personally involved in decisions about the type, the design, and the items of merchandise bearing the Katy Perry mark offered for sale, given her role as the CEO. So that kind of gives her a bit of a distance in terms of the whole claim to the tortfeasor claims.
Exactly. And you're right. So on the who is liable point, it was Katy Perry only, and that was by virtue of the Bravado agreement and the obligations that company had taken on to work with Bravado in selling the clothes and other items in Australia. And that comes on nicely to the other main issue that the court had to work through here. And that was that's a funny thing to be talking about, but what does clothes mean? What does the word clothes mean because clothes, that's all it said. Clothes was the registered item in class 25 on the register. And there was a really interesting kind of dichotomy set up here between some authority that in Australia that had said that what is described on the register is all important, and you look to the register, and the register has paramount importance in assessing what is the item that's protected by the mark. And then another line of cases that had said, well, extraneous material can be looked at as well, and you can look beyond the simple description and look at, other regulations and other aspects of the law that may cast some explanation on what clothes means. And the debate here was because Miss Hudson sold all types of things at her concerts, T-shirts, shoes, socks, headscarves, you name it, costumes, all sorts of things.
So it was quite funny. I found this part of the case really funny because they have two distinguished expert witnesses come on. One has a fine arts and textile degree, and the other one has 30 years of experience in merchandising. And then it boils down to the arguments of what constitutes clothes under the Class 25. And then so when you go through all the different classifications, it goes down to whether or not the item can cover or protect your body, your torso or limbs from the elements. And then that comes under the definition of clothes. But any item that is decorative in nature, fashion jewelry or accessories or bags are not clothes. So, and then there was this really nitty-gritty discussion, what does footwear come under? Does that constitute as clothing? Because it has a protective function, right? And also because Miss Hudson sold footwear via her Perfect Ventures. But the judge in paragraph 339 deemed that footwear was not clothes because that word covered the body but not the extremities of the feet or the head. So yeah, so it's quite a detailed discussion about clothes on there. But it's really important because that's where it boils down to, is all the merchandising, right? So what is clothes? It's
really important. I suspect that this was a big debate because she sold a lot of shoes. That's my take. And shoes are expensive, and I would not be surprised if, I don't know, Katy Perry shoes were a big hit at these concerts and there was a lot on the line.
Yeah, and they were also talking about the manufacturing processes between clothes and shoes. It's much more intricate and much more detailed, difficult to do the shoes. So I guess there would be, just from that very nature, it would have a markup. So I think there was a huge importance on footwear.
What do you understand? What would you say? If someone said to you clothes, would that include shoes, or would that not include shoes? Like just from a common sense, I'm not looking for the legal answer to that.
I'm going to give you a legal or ish depends, because you and I both grew up or lived in Bulli, which is a beach town. Right. So you don't see many people here with shoes.
That's right.
So I wouldn't constitute that as clothes per se. It's just something that protects your feet. You can, so I don't think shoes are clothes. It's part of it finishes your outfit, but it protects your feet.
Yeah, and also I think I agree. I also, now I am going to look at the legal reasons here, but part 1 of Schedule 1 to the regulations, that's the trademarks regulations, 1995. It describes the goods for item number or class 25 as inverted commas, clothing, footwear, headgear, clothes, inverted commas. And so if you then go and register the mark as only clothing or clothes, you're not picking up the other parts of the description, the regulations. And you could argue there's a distinction within the regulations between the different types of items. And so if you then go and only list one of those, there seems to be some distinction there. And this was the debate between the two lines of cases I was saying. Ms. Taylor was arguing, well, you don't look at the regulations, you just look at the definition, the register. They didn't want that argument to kind of come in. And I didn't find that a very convincing point. I'm like, if you've got if you've got regulations that describe or differentiate between clothes, footwear, and headgear, then that is going to be a relevant factor. And it comes back to this reasonable trader, or the objective test, like someone going and looking at the register, what would they understand the mark covers? And if clothes is there without any reference to footwear and headgear, which are mentioned in the regulations, then it would seem to follow that the selection of clothes excludes those other items covered by the class. That is the footwear and the headgear. But then the judge also went on to say, even if wrong on the use of those regulations to come to that understanding of what clothes meant, in the court's opinion, the ordinary meaning of clothes is garments that cover the body but not the feet or the head, as you say. And the court points to two dictionary definitions, which was really interesting because those were two definitions that Miss Taylor relied on, the applicant relied on. And when I read those definitions, I'm like, I'm not sure these help. I'm not sure these actually help her. They don't refer to feetwear. They don't really.
No.
And so,
just talk about dress, apparel.
Yeah, they refer to garments or coverings for the body, or I think it's more consistent with coverings for the torso and limbs, as you say, rather than feet. And as both of us kind of acknowledge, from a common sense perspective, I don't think that many people would say that clothes includes footwear. Some might say that, but
I feel the judge is also hedging her bet because she keeps saying on the alternative. So I think there's a bit of contention, whether she states in the end that shoes are not clothes, but it's almost she's giving an opening that if it on the alternative, this would be the result. So
I think that might be because first instance judges, as they tend to do, which is quite understandable, they try to make their judgments appeal proof. And if they come out on the legal point alone and they rely on the regulations definition to support the decision, and they say, okay, you look at the regulations and you can see there's a distinction between clothes, footwear, and headgear, and that then guides your understanding of what's set out in Class 25. Yeah, if I may say, many times judges, quite understandably, will look to ensure that their decisions are as appellate proof as possible, or appeal proof as possible. And had the judge only relied on the extraneous evidence point around, well, you look at the regulations and the regulations includes this distinction between clothes and footwear and headgear, and that should then guide how you look at the Class 25 designation on the register. And that's a legal point, because there is a split in the decisions about whether you should do that or not. There's a case that suggests you should just look at the register and what clothes means without going beyond that. So if the judge was wrong on that legal point, there's some other fact-finding and legal conclusion that's not just relying upon that point. And that's one reason, perhaps, and I say this with the greatest respect, of course, but it may be one reason why there's additional justification for finding what clothes means based on dictionary definition, based on what the common understanding is, and therefore what the interested trader should understand when they go and look at the register. And just if they were only to go off the question of what does clothes mean without seeing the distinction further on, so there we are. That's how the court dealt with the question of clothes. And so ultimately, the court found that there was an infringement. There was an infringement by Katy Perry on a joint tortfeasor basis with Bravado, and that the claim succeeded against that individual entity. I haven't gone into the goods of the same description point. That was also that was not established. But it was only with respect to clothes on the body. It wasn't with respect to footwear, headgear, and some of the other things. I think it did include party costumes, but primarily it was for clothes as we understand them to be, not the footwear and headgear and other things. So Ms. Taylor succeeded. She succeeded in her claim. She got one of the Katy Perry with a Y companies on the hook here, and we don't know how big that claim kind of is, but anything that's kind of in the clothes department was an infringement.
Yeah, so I think I like what the test the judge was using. So the test has to be real and tangible danger of a reasonable number of people, being caused to wonder whether the clothes might not have a trade connection between the two. So although the two companies sound the same, they differ in appearance, and she says that Miss Hudson's merchandise is accompanied by graphics or photos of the singer, so they're really different. So Miss Hudson and the other respondents weren't successful in stopping Miss Taylor from using her trademark. So that's a win for the small business owner in Australia. But yeah, so the test is real, tangible danger.
Yeah, so the cross claim was tossed. So Katy Perry tried to argue that Miss Taylor should be prevented from continuing to sell her goods, and that was also dismissed. So yeah, ultimately this was a win for the little guy, the Australian designer who'd been going about her business with the clothes, and there'll have to be some reckoning now on what that equates to in terms of the financials.
I mean, she's been trading for 10 years, over 10 years, using her mark. And it's quite scary how little she's earned, really. During the financial year in June 2019, June 2020, she earned between $40,000 and $11,000. So that's not a lot at all. So there was absolutely no evidence of confusion, the judge was saying. I mean, it's just incomparable. And so I think the take-home points for me is maybe as a lawyer, don't give out scary cease and desist letters to small businesses who've got the priority trademark already prioritized. It's already, set in stone almost. And then also maybe if you've got a good case, go to a litigation funder, as Miss Taylor did. So, I mean, this would have been quite a stressful case for her.
Oh, I can imagine. Yeah, this would have been full on. It's not what she kind of anticipated she'd be getting into when she set up a small clothes company, but it's a big win in the end. I'd be really curious to know if we find out what it equates to in terms of numbers. But I dare say she's going to earn. I think she's going to earn more through this than what she ever has in her business.
And even just the side publicity of the case, people going to her website because they're interested about so that's just free publicity, right?
Yeah, but when you think about it, as we said at the outset, if whatever the ultimate amount is that she gets out of this, can't help but think that early on, if there had been a different approach taken rather than the heavy-handed cease and desist approach, that there might have been a collab or some kind of way of smoothing this out so it didn't end up in litigation. Anyway, look, I've enjoyed getting into it. This was a different case than what we usually do. It's great to have you on the podcast, Romina. It's not easy to get through a 200-page decision and try and distill it down into a podcast. So I appreciate your attention to this and time. So thank you. And let's get a case next time that's well in your wheelhouse, hey? This is no worries. All right. Thanks for listening in, everyone. I hope you've enjoyed today's episode, exploring the world of trademark law in Australia between the Katy Perrys. And no singing. So
Singing,
there
no
you go.
research required.
Yeah. Okay. All right.